Good afternoon, everyone. This is Jim Pamplin, co-chair of DREA. Today, we're welcoming Ryan Schrouder. You can see his business information there. Ryan's definitely a friend of DREA. And today, I asked him to come and talk to us about entities. A lot of people are going to be starting businesses next year or may want to look at how they classify themselves. And Ryan, I think this is an important decision, not just for new people, but also for those changing their business. What do you think?
It is. It's an important decision because it has serious financial ramifications based off of the route you choose.
Well, financial ramifications in terms of the taxes, I assume, but also liability issues as well.
There's two issues or two factors to look at when you open any type of business. And the first one is what you spoke about, the taxes, the tax treatment, the way the IRS will look at your entity or ultimately you for purposes of making you pay tax. And the second one is liability. And liability, for instance, your negligence or any type of damage, some type of lawsuit somebody could have against you for your acts, that's all governed and regulated by the state. So the two things you have to look at is one, taxes, which is governed by the Internal Revenue Service, and two, liability, which is governed by your particular state, in our case, Florida.
Okay, so let's start with the people working alone. Okay, the people working alone might choose sole proprietorship, S Corp, or even a one-member LLC. So let's start with them because there's a lot of real estate investors, and I guess maybe we'll talk about PAs because a lot of real estate agents do that.
Absolutely. So just to give you a little history, the way you're organized is based off of state law. In Florida, you have a couple options. You have the default sole proprietor, which is an unincorporated business. It's you decide you're going to mow lawns. You just go out with your mower and start mowing lawns or selling lemonade. You have no protection. There's no entity or layer of shield against any wrongdoing or anything. You run over Johnny's toe, cut off his toe, you're going to be sued, for that act, so to say. And so that's the basic. You don't have to do anything to open a sole proprietor. You just go out there and start operating, and that provides the least protection. So that's what you're going to be if you don't incorporate or create some type of entity. Then you spoke about some other ones, and so the question is, if you're going to try to protect yourself from liability under state law, which entity do you become? And there's your next question. And you mentioned a couple. You mentioned
the S Corp or a single member LLC.
So under the state law, you have LLCs, limited liability corporations. You have for-profit corporations, corps we call. So you have, let me back up, limited liability companies. So an LLC is a limited liability company. Then you have for-profit corporations, and those are your main ones. But essentially, for anyone who's watching this, they're going to have the option to either be an LLC or corporation. And if their business is professional in nature, like an accountant or a lawyer or maybe a real estate agent, they have the ability to be a professional corporation, which we call a PA, professional association, in Florida.
So that, in essence, is like a corporation.
It's like a corporation. Traditionally, you could not shield professional acts from direct liability. Now you can. So the laws have been laxed over time, and professional associations are permitted. Law offices, accountants, anything that's licensed, they can actually incorporate as a professional association. There are some limits on that. They have to operate within that scope, all the owners of that professional association. So if you wanted to start a PA, that's a real estate brokerage, you have to only provide those services, the real estate brokerage services. All the owners, they would be required to be licensed real estate agents. So you wouldn't be able to start a PA that's, you and I couldn't go in on a PA for a CPA firm if we're not licensed CPAs type of thing.
I see. Okay. So then there's a benefit to a person working alone to becoming a limited liability company.
There is, for your actual liability under state law, you want to be an entity. So whether that be an LLC, a corporation, or professional corporation, you want that limit to the liability. You want your risk as an owner capped max at your investment in the company. So you don't want to be personally liable for the acts of your employees or anything else. Which route you take is often based off of tax treatment. So, for instance, we're going to have to switch hats a little bit, but under the IRS code, when they're taxing, there's basically 4 taxing methods they look at. The IRS is going to treat you as a sole proprietor, a partnership, a S corporation, or a C corporation.
Okay.
Those are your basic things. And a lot of times your most profitable or most advantageous route is to be an S corporation. So the corporation is not taxed. And then when it does a distribution, the shareholders are again taxed. That's the common reference. You'll hear double taxation. And so S corporations avoid that, but the IRS doesn't allow everyone to be an S corporation. So if you want to be an S corporation, you can do it as an LLC or as a corporation or as a PA, but yeah, you have to have 100 shareholders or less, all have to be natural citizens. None of the shareholders can be entities. So you can't have your LLC own another LLC. Two things. One, you don't have to pay corporate tax and then again, ordinary income on it.
Right.
On your distributions, you do not have to pay your self-employment tax.
Okay.
So you can't be an S corp if you're going to have an entity involved, or if you're going to have more than 100 shareholders. You're limited, and if that's the case, you're going to be an LLC. So if your partner is also a natural person, not a company, and is U.S. citizen, then you guys can elect to be taxed as an S corp. Now there are some requirements. You can't have, for example, uneven distribution. So if your partner is 70% and you're 30%, you can't, give out 50-50 profits. You have to do it 70-30. But if you meet these requirements, that's a great way often to be taxed as the S corp.
So if you form an LLC with 2 entities as the member, then it defaults to a partnership. Is that correct?
Correct.
Okay.
And you're not going to be able to be taxed as an S corp.
Okay.
Because those two owners are not natural people. They're like you said, other entities.
Okay.
You might then later on at your other entity level be done as an S corp, a further flow down, but at the initial one, that entity won't be.
So 2 individuals working together in their own names, as opposed to having entities as members of an LLC, if they're individually personally members, then they can elect to be taxed as an S corp.
Yes.
Okay, that's a little thick, guys, and we're going to put this on the screen for you a couple of times so you can see it and have reference for your attorney and your accountant.
Before we jump in, I'm going to give another analogy that helps people understand. Often you'll have people go out and create an LLC and they do not check with their accountant like they should, and they do not elect to be taxed as an S corp. So what happens is any profits they make, whether it's a partnership or sole proprietor, flows onto their tax return. And so if they make $100,000, they're going to be paying ordinary income on $100,000 plus the self-employment, which everyone knows. Basically, you pay the employee part and the employer part,
Right.
which comes out to about 15%. Whereas if you did it like an S corp, a lot of times you'll take a salary of that $100,000. You might take a $30,000, $40,000 salary, and then on the other $60,000, you take as a distribution, and you're not paying the self-employment tax. So you're saving 15% on that. And that is where at the end of the year they go, oh wow, I didn't realize I paid this 15% higher on a good portion of their profits. It's very important ahead of time if they go out and open up, they speak with an accountant to make sure that they're set up right. They don't need to change to an S corp.
Okay. Well, that brings to mind, if you're operating as a partnership and you earn $100,000, the partnership does, and you leave 10,000 in the business at the end of the year, you're still going to pay tax on that $10,000.
Scenario, it's flowing through to your personal tax return. Any scenario other than the corporate tax situation, the C corp, which is not realistic for most individuals. I mean, that's big companies usually in that situation.
Okay. So in either in an LLC taxed as a partnership or as an S corp, all the earnings, whether you take them out or not, are going to flow through to your tax return.
They're going to flow through your tax return. I hate to delve into another very important subject, but that brings me to, before you get into a business relationship with somebody, you should have some type of operating agreement or some type of agreement, because when it flows through, for example, if we made $1 million and I'm the 51% shareholder and you're the 49% shareholder, I can say, I don't think we should release any of the money. It should stay in the business. But you're still going to pay tax on that. It still flows through your tax return. So you could be taxed on money you don't have access to. And that's a typical common, we call, squeeze out of a minority shareholder.
Right. And I've seen it happen. I have people come to me all the time saying, wait a minute, my partner doesn't agree with, we need the money, we've got to pay the tax. And that's when they're saying it.
Yeah.
Let's talk about liability. I'm a firm believer in insurance. I buy all the insurance I can buy. I have general liability. Every property I buy has a separate liability policy. DRIA has a liability policy. Now, I'm aware that the entity protects us, but I think the best form of liability protection is insurance. What do you think?
Insurance is a phenomenal liability protection. Most of these other ways where we're talking about creating entities, they're really layers. They're not absolute. I mean, neither is insurance. You have to make sure you read the contract. But if you're within the corners of your insurance contract, you're going to have phenomenal coverage. And all these other ways are just layers.
Yeah, but no entity is going to protect you from bad acts.
No entity is going to protect you from your bad acts. So your individual fraud or your individual malpractice, you're not going to have protection from. Now, if you you have employees that do something wrong, your liability personally is going to be capped at the entity level. So that's the good thing about the having an LLC or a corporation. You're not going to be personally liable for the acts of some of your employees.
But you're also, if you're an LLC versus a partnership, the same rule applies. If you're just a general partnership, you are liable for your partner's acts. Is that correct?
In general partnerships, you are liable for the acts of your partners. Absolutely. And that's why it goes back to the old common law days where you were very particular on who you're going to let in to be your partner, because you are going to be ultimately on the hook for their acts within the scope of the partnership. I mean, if you have a real estate partnership and someone goes out and gets drunk and runs someone over, that's not going to be within the wheelhouse of your liability. But if it's something within the scope of the partnership, you're liable, and not limited to your partnership ownership, your actual personal liability as well.
So an operating agreement is something that partners should have, general partners or limited liability partners. And that is something that a lot of people don't think about. Just give me a ballpark, just a ballpark of what it should cover.
Just in case there's some attorneys watching this, I don't want them to, cringe. I want to correct a little bit of terminology. So your operating agreement is what you would do for any LLC. If you had a partnership, you have a partnership agreement. If it's a corporation, you have a shareholder agreement. But essentially, it's all the same. It's an agreement amongst the owners and how it's going to be operated. And so your question was, what are some of the things that would be included in that?
Right.
You're going to have included in it who's going to be responsible for handling the tax issues, when property or when assets or business affairs, what the purpose of the company is, what material decisions will be voted on by everyone, Maybe you have things in there saying what the company won't be doing. Whether someone compete, they can't compete. But one of the big things is going to be whether or not minimum distributions are going to be done. And so with any type of S corporation or any type of corporation where or LLC, any type of entity at all where the taxes are flowing on your personal tax return, your agreement should say that that entity at a minimum is going to distribute enough money each year to cover each owner's proportionate share of the taxes. And so that prevents you from getting the company having $1 million in profit, the majority not wanting to distribute it, and you having to pay tax on your share, which, I mean, that really is what saves you. So there should be an agreement in there saying that enough will be distributed
To pay the tax.
to cover that. Other things are what happens with your ownership interest or your partner's ownership interest if they get divorced. Does it allow an ex-spouse to come in and get a portion of their, there's all kinds of things. Or if one of the partners dies, do the other partners have the right to buy? Or are these interests going to be inherited to someone else and they have to deal with someone they don't want to? In the case of an S corporation, when you're being taxed as an S corporation, which has serious benefits a lot of times, you'll often put in the shareholder agreement that shareholders cannot do anything to jeopardize the S corporation status. And so that would mean they can't sell a share, one of their shares of stock over to a non-U.S. citizen, because boom, they do that, and the next thing you know, you have a double taxation. You blow the S election, or different type of things on you want to protect against. Whether they can't renounce their citizenship. You hear these sovereign citizens. You renounce your citizenship, you blow the S election, and it impacts everyone. What the IRS or what Congress did was include in the Internal Revenue Code the S corporation, where you can be an S corporation. But that's where we went into a few rules, and you can be an S corporation and pass through all your taxes at the corporate level to the individual shareholders, contingent upon having 100 owners or less, them all being U.S. citizens, and natural people. So it can't be an entity. It can't be, a non-U.S. citizen. It has to be 100 shareholders or less. And there's a few other guidelines. You can't have 50% shareholder getting 90% of the distributions. So what ends up happening is if you do anything against these rules, it will be deemed blowing the S election, and the IRS could come back in and retax you. So if they say, all right, Viju and Jim are 50-50 partners, but last year Jim got 90% of the money and Viju got 10%, those were unequal distributions, then no, that's not allowed under the S election rules. So we're going to cash it, and we're going to go tax an extra 35% or whatever the corporate tax rate is on all the profits for that year. I mean, it could take a company out of business.
Okay. Well, those are very important considerations. So I want people to pay attention to this information that's on the screen here and there. It's really important. And talk to your accountant and talk to your CPA before forming an entity. Now, Ryan, the last thing I want to talk about, and it's probably minimal, but it's something we should talk about, is record keeping required for a corporation versus an LLC.
This is a double-edged sword. So with a corporation, you're required to have some better record keeping. You're supposed to have an annual meeting, supposed to have minutes, board of directors, and really some extra formalities, because the existence of corporations have long predate LLCs are relatively new. And an LLC, you don't have these formal requirements to have it, and this is good and bad. When it gets in, if you get into a shareholder or a partnership dispute, in my opinion, the corporate statutes are easier to litigate under and to ensure fairness, because they've been around longer. They've just, hundreds of years. The LLCs haven't. So it's a double-edged sword. Yes, your records don't need to be kept as well, but also the law is more defined with corporations. So I mean, a lot of people push LLCs. I'm like a big corporation fan unless there's a reason why. And I'll jump into one other thing. You certainly have to talk to your accountant, but when you're actually holding real estate, not necessarily, providing a service, a lot of times the tax basis is better to hold real estate in an LLC instead of an S corp. I don't know the exact particulars. I think it's basically the step up on when it's sold. Effect. You would ask your accountant for that details on that. But unless you have one of these specific situations where an LLC makes more sense, I think you should default to a corporation if you can. If I could add one thing, not to do any war stories because I don't want to scare anyone, but when we open these up, a lot of times we go on Sunbiz and we open it up. We don't order a corporate book. We're really more worried about making money than we are the formalities. But I have to tell you, there are several situations where big companies spawned out of these small in the garage situations, and it was troublesome that they didn't have any formalities or any shareholder agreement or anything. I mean, I was involved in a situation where some real estate professionals in the South Florida area opened up, a corporation, which resulted in being ultimately, when it got to us, was a multi-million-dollar lawsuit. It was a huge corporation, and it's scary that there's a lot of these things were not, done. So, I mean, I get it. You want to open it up and get rolling, but as soon as you start seeing, there's going to be some real assets or the business is taking off, you got to make sure you stop and everyone sorts out these corporate or company formalities and have these written agreements. One of the individuals ends up in bankruptcy. You have the bankruptcy trustee comes in their shoes, and now you're no longer business partners with your best friend. Now you're business partners with a nasty trustee lawyer from the bankruptcy court. So I don't want to under impress how important it is to have shareholder agreements, operating agreements, partnership agreements in place to avoid really, really bad situations. I'm sure that Facebook partners wish they had written agreements.
Ryan, thank you. We hope we'll get to see you in person early next year. We'll see how it goes. Okay.
Absolutely. Stay well. Take care.
Bye-bye.